Hi everyone, it's 9 o'clock. There's still some people signing in, so I'll start with the introduction. Presentation will start in about 5 minutes. So, what are we doing today? Today, we're talking about the introduction to legal methods. Now, those of you who managed to tune into my last Zoom session, I had done an historical introduction to the law of India. And today, we're going to learn how we work that law in India. Tosha, you had something to say? All right. I'm just requesting everyone to put their microphones on mute unless they have a question. So, all right. So that's it. Great. Thanks. So today we're going to learn legal methods. And now this is a very brief intro. It's done for the benefit of the general public. The idea is that if you hear this one and the one I did previously, which I'll share the YouTube link if you're interested, you should be in a position to understand the topics that I am going to do going forward, in which we'll start doing some more substantive law. All right. So this is basically for to give you a brief introduction as to how the law works in India. So we learned the historical introduction to the law. Now we will learn the current way this law is operated, as in how do we operate the law. So now the first question we ask in something like this is, what are we going to be covering, obviously? So I had said this in my intro, but here. So today we'll be covering the sources of Indian law, what is legislation, how the legislature makes the law, statutory interpretation, how the courts enforce the law, what is precedent and why is it very important in our system of law, and an introduction into what are called forms of action. So there are multiple legal actions, but each one takes a different form. So forms of action is important as in order to actually reconcile it with your reliefs. All right. So let's start with the first topic here. Uh, One second. I still think people are signing in. Do you think we should give them few minutes? Or do you want me to start? All right. Anyway, let them join. All right. So, can anyone who's listening tell me what we mean by the crown? I know you all watch the Netflix show, but can anyone tell me what we mean legally when we say crown? Any ideas? Anyone's got it? Feel free to chat, unmute your microphone, and join in. Okay, so in a common law system such as ours, which we're largely modeled on, we're not purely common law as I explained last time, you have the idea of the monarch, right? And the monarch is the source of all power, all legal power, be it executive, legislative, and judicial. They all flow from the monarch. Now, we keep saying that these are constitutional monarchies. Yes, they're constitutional. There are two types, right? There are monarchies established by constitution, and then there is a monarchy that functions within a constitution, right? Examples of monarchies that are established by a constitution are like Spain and Belgium, which have proper written enacted constitutions. Monarchies that are governed and restricted by a constitution will be the British monarchy, right? Which is also the monarchy for Canada, Australia, New Zealand, and all of these things. In these semblance in the common law, what we use the word the crown. Now, the crown is the source of all legal power. Now, from the crown, you can derive the legislative power. The crown, through parliament, exercises the power of legislation. The crown, through the courts, exercises the judicial power. The crown, through its ministers, exercises the executive power. Now, in our system, after independence in 47 and the constitution in 50, all these three powers now flow from the constitution. There is no more a crown in India. The role of the crown has been replaced by constitution. Though in popular civics, you would have been largely led to understand that the president of India performs the role of the monarch in India, the same way Elizabeth performs the role of the monarch in England, right? Elizabeth the second. But that's not the case, exactly speaking, right? So while in Britain they actually have a crown, in India, the president of India exercises enumerated responsibilities on behalf of the crown. Right. So the president of India doesn't have inherent powers that comes with the crown. As in the idea of inherent executive powers to do whatever you want is very difficult. In England tomorrow, the crown, which is Elizabeth, she could legally step outside and dissolve the entire country, because that is the absolute amount of power that's vested with her. Now, whether she exercised it in accordance with the law or not is a different question. But she has that power. In India, the president does not have the power. The president cannot dismiss all of parliament. The president can't suspend the constitution. So he performs some ceremonial functions that are required for the crown, the president, but the president is not your crown. Your crown in India, in the easiest way for you to understand it, is the constitution. And now from the constitution, you've got three types of authority that emanate. You've got the executive authority, you've got the legislative authority, and then you've got the judicial authority. Now, this is what we call a separation of powers, that these three branches are independent. We will later learn that they may not really be fully independent of each other by design. But that's a different question and a story. So, what is the source of legislative authority? The source of legislative authority is the Constitution. So, the Constitution creates two legislatures, the legislature at the union level and the legislature at the state level are constitutionally sanctioned. Then, for the union territories, you have legislatures that are creatures of statute. They are not creatures of the constitution, except for some union territories. So, like Delhi, for example, has limited legislature. Like they can do whatever they want, but there are some powers that the central government still holds over Delhi, such as the police power, which is something we've been discussing at length over these last year or so, seeing the behavior that's been happening in Delhi. Uh, it's become painfully obvious to us that despite there being an elected state government, the police power in Delhi is being exercised by the central government, which is okay, right? Because Delhi is not a state. If it had a state, then it would have the powers. The constitution creates the legislatures, and it also entrusts them with powers. And this is done in the seventh schedule to the constitution, in which we have a concept known as lists. So there are three lists. There is list one, list two, list three. List one is all matters on which the union legislature has exclusive authority. List two is state legislature has exclusive authority. List three is both the legislatures can rule on these subjects, but if there is a conflict, the central law prevails over the state law. Then there is also the power of parliament to give effect to treaties and international arrangements, which it can do notwithstanding anything that is within the domain of the states. And there are also some strange provisions by which two or states may by consent ask parliament to make a law for them, which is in the period of consent. So the source of legislative authority comes from this. Now, there is it's very popular to say we are a democracy, but India is not a democracy. We are a democratic republic with an elected legislature. What do I mean by this? I mean that it is not just the popular mandate that gives the legislature the authority. We have two houses of parliament, at least at the union level. We've got the lower house, which is elected by universal franchise, and using first past the post in a variety of constituencies, these MPs are returned, which results in a situation where you could have a party with a super majority almost without actually winning 50% of the popular vote, right? Then you've got the Rajya Sabha, who are your elected representatives from the state legislatures. So your assembly, let's say if you live in Maharashtra, Maharashtra is entitled to send certain number of people to the Rajya Sabha, right? And the Maharashtra legislature, the Maharashtra assembly and the council, they are responsible for electing these members. So these members are done by indirect election. The President of India is elected by an indirect election involving both the houses of parliament and all the state legislatures together. So you and I, the average citizen, we don't have the permission to vote for the President of India. As in, it's an indirect election. Now, in some states, Karnataka, Maharashtra, for example, there are two houses of the state legislature as well. They are the lower house, which is the assembly. Every state must have an assembly. Some states end up having an upper house, known as the legislative council. The legislative council is not just first past the post, whoever wins that goes in, right? You have each legislative council is different in its composition. Some states, for example, reserve seats for lawyers, teachers, doctors in their legislative councils that you can only contest for these seats. Some of them have graduate constituencies. So only graduates of particular universities may take up may stand for election for those legislative posts, legislative council seats. You also have governors nominated members, where the governor using their powers can nominate members to the legislative council. So the source of legislative authority is not democratic. You can't say parliament enforces the will of the people. No, parliament is an institution like everything else. There is a certain amount of representation for democratic voices in the constitutional framework, but the constitution is not a democracy in the way Athens was, like we discussed in the last lecture, right? You know, where the majority decision moves. There is no triumph of the majority. When we study the constitution, you will see how that becomes painfully evident in the way the fundamental rights are worded, right? So, what do legislatures do? Legislatures, here is where we come to this idea, is that what is a statute? Okay, now if you read the earliest statutes in the English law system, you will see that they are the same as speeches. And we, being the crown is always plural. We hereby do ordain something that is, any man doth commit this offense, he shall be punished with a felony. Parliamentary statutes today look like modern, proper, look a lot more as in are more clearly defined, contain word, are more specific, have section numbers and things like that. Old statutes did, but that gives you a good indication of what is a statute. A statute is the expression of the will of the sovereign, right, in the traditional English law system. So, an act of parliament is parliament expressing its will. That parliament hereby enacts into law the following, that the following will of parliament shall have the force of law. Doesn't mean everything done by parliament has the force of law. Parliament at times keeps passing resolutions that parliament is hereby resolved to do this. Now that is not law. It must be a statute. And a statute begins with a bill. And the reason it's called a bill is that the purpose of parliament was always to make sure that the king or queen of England could lawfully raise money. So from Magna Carta onwards, 1250, the English sovereign couldn't raise taxes without the consent of parliament, right? So every year the sovereign would summon parliament so that the sovereign's expenses could be paid off by taxes. And these, when I mean the sovereign's expenses, I mean the country's expenses. So would be paid off by a tax. So the parliament would be summoned by the crown, and the crown would present to parliament an agenda and saying that this is what I estimated. Can you allow me to use these funds? And then parliament would sit together and say, okay, fair enough, you can spend this much money. This is known as the legislative power of the purse. So no wonder that these motions start with bills. It's basically the crown submitting, this is my bill of expenses, or these are my bill of things for this year. Like, this is what I will need for this year. This is my budget, right? So that is how it starts with a bill, and a bill has to go through both houses if there are both houses, or one house if there is one house. Bills regarding money can only be raised in the lower house. This is a convention that emerged in the 30s, which we put into our constitution when it emerged, primarily because of David Lloyd George and his people's budget crisis that he had the 20s, just before World War I. Right, when he tried to pass a very populist budget and the House of Lords kept blocking it. So they made the Parliament Acts in England to basically allow financial control to be with the lower house. India saw the Parliament Acts and said, this seems like a good idea, let's keep it in our constitution. So money bills are always raised. So these are known as supply. Uh, so now you see why a no confidence motion exists, right? So why the prime minister can only serve as long as the lower house their prime minister has the support. Because the whole purpose of the minister of the crown is to ensure that the government can continue, right? And if parliament is unwilling to pay this minister's bill, which is the budget, the entire administration comes to a stop. So if the lower house has no confidence in the government of India, then there will be no budget if you do not have a majority in the government. And if you do not have that, and if you do not have the budget, there is no point. Hi, sorry, can you hear me louder now, Tosha? So if you do not have a budget, then you literally have no point of government. So that is why this becomes important as far as a bill is concerned. Now, second is customs. So India recognizes the legal validity of certain customs. Now, these become relevant only in personal and religious law in India, but we recognize their legal validity as long as they do not conflict with an act of parliament. All right. So parliament can tomorrow decide I'm destroying a custom. That is within parliament's power, right? But customs maintain the force of law until and unless statute or the constitution tells them go take a hike, right? So the customs otherwise would exist. Well, and you would see that sometimes there is statutory recognition for customs. For example, under the Hindu Marriage Act, there is no procedure for two Hindus to get married. Uh, as in, it doesn't say that you shall complete this ritual, this ritual, this ritual. It doesn't say that. The Hindu Marriage Act basically starts with who are Hindus for the purposes of the Hindu Marriage Act. What are the minimum requirements for a validly concluded Hindu marriage? When can you contract marriage? How do you do divorce? What happens there? Now, a marriage can be contracted by the rights of the customs of either party. So these customs are accordingly given the recognition of law there. In Tamil Nadu, for example, the exchange of the male, as in what do you call flowers on the neck, right, will be enough to suffice in front of witnesses is sufficient to conclude a marriage. So the Satfera concept doesn't exist. So these customs are given recognition. All of Islamic personal law, except for the Muslim Women Dissolution of Marriages Act, the Shariat Act, and the recent Triple Talaq Act, emerges from this customary source. This custom is reflected in the religious text, but this is largely customary law. And further, customary law has some certain conditions, right? That the custom must not be perverse, it must not be against public policy, and further, it must be a custom that must be there from time immemorial. Time immemorial. I cannot create a custom today. The custom must have already existed, which is why time immemorial becomes important. If you remember the first class, or if you've gone through the presentation or the video, this refresher, I kept maintaining that 1066 was an important date in England and Wales, right? Because after that, you had a settlement of the rights via the Doomsday Book. Similarly, in India, it would have been 1857 when the British Crown took over. So, like in England, anything prior to 1066, as long as it existed, is existing since time immemorial. So, if you had a custom that existed on 1066 until Parliament had destroyed it via statute, or a court had said that it had outlived its purpose or it was contrary to public policy, that custom would still have the force of law. Similar is the situation in India with 1857. In 1857 is where the doctrine of reception begins, right? So if your custom existed on 1857, then it is there for time immemorial. You cannot have a custom created in the last 150 years and try and enforce it under customary law. All right. Now, statutes, you can see how clearly that they would always be in writing. Now, the constitution is a kind of statute, but it's not a statute of parliament. So you can't say the constitution is an act of parliament, but you can classify the written constitution as a statute because it was enacted by a legislature known as the Constituent Assembly. That is why the word in the preamble also says enact and give it to ourselves. The Constituent Assembly enacted the constitution and repealed the Government of India Act 1935. Now, the what distinction now is between written and unwritten law. Now, statutes, etc., are all clearly there in writing. Now you'll come and tell me, Ajay, therefore there is no unwritten law, because if you read the case laws, you will find that the laws have been declared. No, that is not the case here. In a common law system, law emerges prior to the government. So the system works on a series of axioms that keep changing, and these axioms have not been defined yet. As in, we only understand them through case law, but I am yet to find an academic source of philosophical study which has actually turned these axioms into the calculus that they are. All right. So in a common law system, the beauty of the common law is the common law automatically keeps adjusting itself to the changing requirements of society. All right. So for some contracts, there are stricter standards generated by the courts for injunctions, looking at the commercial way these contracts are created, and sometimes they are looser done. For example, the court will look at an employment agreement very charitably in favor of the employee and not as the employer. But when it, and this would have been the case in 1950, right? But today, when you have a non-compete clause before the same court, the court now has enough information to understand why a non-compete is needed. It may not have had it then. That change happens before anyone notices it, records it. Okay, that is the undeclared portion of the unwritten law. The second is the declared portion of the unwritten law. Now, the unwritten laws of India are your basic laws, like your common laws. While the Contract Act is codified, the Contract Act does not cover the entire law of contract in India. There is no law of tort that is written by Parliament. So if tomorrow someone has negligently damaged my property or has trespassed into my property, I will finally claim relief on the basis of unwritten law, which has been declared by courts to have existed. So which is why your code of civil procedure gives a civil court jurisdiction for all civil disputes. So you do not file a case under the Contract Act. You do not file a case under the Transfer of Property Act. You file a case under Section 9 of the CPC to enforce the law. And this law is written, unwritten, declared, and undeclared. And we will see in the next couple of parts where we talk about how courts actually end up making law, how undeclared law moves to declared law. And this is very important because merely declaration of law does not mean that the law exists from that date. The law would have existed before the time of declaration. So you cannot say now the position of law has changed. No, that law was always there. Now the position has been declared. 1 second, how do I switch slides? Yeah. So now let's go to legislation, right? So now in legislation, I'm going to talk to you about exercise of legislative authority, legislative competence, what is separation of powers, what do we mean by legislative oversight, and a brief, and I'm being very brief, intro into legislative procedure, primarily so you can understand what the news is talking about when there is a bill in parliament, right? So like we discussed earlier, the source of all legislative power in India now is the Constitution. Okay, and each legislature, the union and the state, have their own respective domains under which they can legislate. Now, exercise of legislative authority, therefore, is automatically done by the legislature, right? But it's not like parliament is sitting there 365 days a year, even though that is not prohibited, right? So parliament is not sitting there 365 days a year. So the constitution gives legislative authority to governors and the president to exercise powers within the center and the state's domain if they feel there is an emergent need for law and that law can be made before the legislature is in session. These are called ordinances, right? The ordinance is supposed to be presented to the legislature as soon as it reconvenes. Constitution requires that parliament meets for particular times in a year. So does this. It also requires the state legislature to meet for a particular period of years. So ordinances are time bound. Now what happens with an ordinance is if the legislature approves the ordinance remains the ordinance in perpetuity. Now the legislature most times what it does is it repeals the ordinance and passes an act. So the ordinance is sometimes legislative authority is exercised by the executive, the governor and the president. With regards to the armed forces, there's an Armed Forces Act but the rules and regulations of the armed forces are done by the President of India in exercise of his executive power as Supreme Commander of the armed forces. So he has that level of legislative authority there. One second. Uh, here. Ha. So good question, Pradeep. Do you mind posting the wait? Can I just? I'm just unmuting your mic. Do you mind asking everyone that question? Pradeep, go ahead.
Yeah. So how state government law and central government law differently passed and why it differs from state to state?
All right. This is a good question. So now let's come to the question of legislative competence, where this will be answered. Now, legislative competence, as I discussed earlier, is within a field of lists, right? So there is a central power, there is a state power, and then there is a concurrent power. So under the state power, different states have permission to pass multiple types, any law they want pertaining to their list. So let us look at something like law and order, which is exclusively in the state list, right? So law and order, Maharashtra has full permission to have a different law for its police than, let us say, Andhra Pradesh or Tamil Nadu, right? And this is because the constitution makers wanted India to be a union with a federal character. So on ground situation will be different in Maharashtra than say with Kerala with regard to some issues. Now, some issues are best dealt with at the national level. Some issues are best dealt with at the state level. So laws differ from state to state, right? So state laws are passed by the state legislature with the residents of the state electing that legislature. So state laws will vary from state to state. And a beautiful example of this is stamp duty. Right, stamp duty rates vary from state to state. But income tax being a central law, there is one national uniform rate of income taxation. So this is within the constitutional scheme. Then the next logical question that comes is, but if law and order is a state subject, how is there an Indian penal code? Right? And that is what we will be discussing with what are known as central acts and doctrine of occupied field. Okay, so before the constitution came and made these lists permanent, there were lots of laws in India, right? So what the constitution basically says is that anything that was before the constitution continues to remain law unless it violates fundamental rights. Now, if it doesn't violate fundamental rights, even if it's on a state subject, it continues to remain law till the competent legislature decides otherwise. Now, this was something I pointed out during the 377 debate when certain state governments when were expressing a view that 377 should have gone. And it is completely within the legislative competence of the state government to have decriminalized 377 within their states. Except for criminal matters in the IPC that move to the domain of the union. And these are only that one chapter with offenses against the state and offenses against in relation to currency and maybe administration of justice. You can stretch it there. Everything else is within the state's domain. So Maharashtra tomorrow could decide that it wants to remove the death penalty for murder. And that is Maharashtra has that power under the constitution. Now, how it is exercised is a different question. But it has that power. Just like Maharashtra now has its own Stamp Act and doesn't deal with the Indian Stamp Act. So that is how this works. So laws are constitutionally designed to differ from state to state as far as certain subjects are concerned. And for certain subjects, we need a uniform law, which is why GST needed a constitutional amendment, right? Because the levying of sales tax was always within the power of the states. So each state has its own GST tax. It is only the central government, in coordination with the GST Council, that sets the uniform rate of GST to be collected. So your CGST and SGST are usually the same rate. And this is done to ensure that there is interstate movement of goods and commerce, right? Because otherwise what would happen is you could clear a good in Mumbai port, pay customs, but you would have to pay the VAT in Bombay and then move to Kerala. And when you move to Kerala, you will have to claim a refund from Karnataka and Maharashtra for that excess amount because the good was finally sold there and Kerala is supposed to take the tax. So to harmonize all of this nonsense of input credit, output credit across state lines, this is created.
But the second wonderful thing you have to remember is Parliament is vested with exclusive jurisdiction over all interstate matters, right? So right now, if I'm in Maharashtra, Maharashtra government controls everything as far as list 2 is concerned, and wherever there is law on list 3. The minute I am crossing into Andhra Pradesh from Maharashtra, it could easily be arguable that I'm moving into Andhra Pradesh's jurisdiction, and then all of Andhra's laws will apply to me. Fair enough, right? But the central government can do whatever it wants as far as this act of me crossing the border is concerned. I hope that answers your question, Pradeep. All right, now let's move to legislative oversight. And what do we mean by, separation of powers and legislative oversight, right? So separation of powers basically means that what the executive branch can do, this legislature cannot. What the legislature can do, the executive branch cannot. And what the judiciary can do, neither the two of them can do. That is the idea of separation of powers. But the constitution is very clear. The president is a key player in parliament. So as far as the executive and the legislature is concerned, in a common law Westminster system, there is no strict sense of separation of powers like you have in America. See, because here your prime minister, etc., have to be members of parliament in order to hold their offices. So India doesn't have a strict model of separation of powers, but it is very clear that judicial power is vested in the courts and in the courts only. So that is where the judicial power of parliament is. Parliament doesn't have a judicial power, but that doesn't mean parliament doesn't have judicial power, right? When it comes to impeaching judges and impeaching the president of India, parliament sits as a court. And impeachment is a charge. And after the impeachment trial, parliament votes as a jury on whether to convict the president or convict the judge of something that warrants their impeachment. Right? So parliament at times acts as a court. Further, parliament also has the power to punish for breach of privilege of the house. Now, this is a tool employed by some legislatures, sometimes by parliaments, mostly by state legislatures, to shut down legitimate critics of the administration. So they'll say, you have breached the privilege of the house, so I'm going to put you in jail. But these usually get struck down. But parliament does have the power to punish for contempt and breach of privilege, which is largely judicial powers, but it has that power. So if parliament summons you to come give evidence before parliament and you willingly refuse to, parliament can lock you till you give that evidence. Parliament has that power. It's called the power of contempt. What is legislative oversight is a little different from a statute. Now we discussed earlier that a statute is an expression of the will of parliament, right? So let us take something called the Aircraft Act. Now, obviously, no one in parliament knows what are the specific technical requirements for landing and taking off an aircraft, right? And these will change depending on the make and model of the aircraft. So what does parliament do? It gives the power to the government to make rules and notifications and bylaws. All right. Now, legislative oversight is basically that when it is just a procedural power you're delegating, right? Let's say you delegate the power to say that if you create a law that says that everyone shall have the right to move court if they have their chicken stolen from them, you can delegate the power to the central government as to how the complaint has to be worded, the form of the complaint for the theft of chicken. Okay, so that can be delegated without issues. You cannot delegate the power to parliament to decide what animals will get that status, because that is a question of policy, right? Delegating that is the legislature basically just abandoning its duty. So what you do there is you delegate that power, but you say Parliament says to the central government, every time you use that power, you come back and tell me how you used it. And if I think you used it wrong, I'm going to tell you to go away. This is known as laying of delegated legislation. All of your RFEMA policies, for example, have to be laid before the Houses of Parliament before they gain any legal force. So that's your legislative oversight. Now, you cannot delegate too much. You can delegate, and how you delegate also matters, as long as legislative oversight is a concept that as long as there is legislative oversight where it's required and you are not delegating the policy making function. As in, you cannot pass a law tomorrow saying supreme power to the Prime Minister Act, saying that the Prime Minister of India shall have the power, notwithstanding any law made by Parliament, to make any regulation for whatever wish they want.
a power that is currently being exercised by the Home Ministry of the state and the center, in which they are making regulations under the DMA and the EDA, right, which are going notwithstanding any other laws. And under the DMA, Disaster Management Act, at least these are being laid before Parliament. My bigger question is, under the Epidemic Diseases Act, there is no laying provision, right? How are they legally doing this? Can the legislature simply abandon its responsibility without the constitution providing for it? It is for the legislature to tell me whether I'm allowed to sit inside the house or not, not for the state government, right? We are a nation of laws. But this is happening, but who's going to challenge it? As in, you're going to be a pariah if you go and make this noise. But this noise is there, and this is a problem. Our constitution didn't plan for an epidemic. It didn't plan for it. Now we are here. We have to do what we can. I guess that is the only answer to this problem. Now, as far as legislative procedure is concerned, like I mentioned earlier, it starts with a bill. A bill usually is read for the first time, and then the House passes a motion, whichever House of Parliament. So let's say it's the Lok Sabha. Lok Sabha passes a motion saying, great, we will take up this bill for discussion. Then the bill is referred to committee, and the committee comes back with its second reading with its suggestions and amendments, and these amendments are put in the bill. That's known as the second reading of the bill. Then the third time the bill is read, it is considered to have passed. Then it goes to the other House of Parliament where it is read 3 times, and then it goes to the president for the signature. And once the president gives the signature, the bill becomes law. There's no time limit prescribed for the president to give the signature, but the law says that if the president says no to a bill and parliament sends it back to the president, then the president has to sign it. But the law is very silent about how long the president has to take to sign a bill the first time it's presented to the president, which means this is known as a pocket veto. So a classic bill is the postal bill that Rajiv Gandhi tried to bring in. He tried to bring in a bill that allowed you all to allow the government to read your letters. I forget the president. I think it was Zali Singh. I think, I'm not sure. The president at that time basically refused to sign it and refused to reject it and kept the bill with him pending. That bill is still pending with the president. So that's known as a pocket veto that the president has. When we deal with the constitution, we will dedicate lots of time to the president because that is a topic most people don't discuss, right? When you read constitution, you all have read about fundamental rights on some level. Who is the president and what powers the president has? Is something that you need to, that every citizen should be aware of. After all, he is the first citizen of the country. Let's know what he's up to. Now, next we're coming to a topic that is something that I personally enjoy immensely. This is called statutory interpretation. How do courts interpret the statutes made by Parliament? Now, I have kept this graph specifically the way it is because the gap in the middle, right, is supposed to represent the judge. So, what has to be done when interpreting legislation? Now, as far as possible, courts will aim to give effect to the will expressed by Parliament. So, courts are not going to blindly invalidate a statute. Like if Parliament if you're present a court with an act of Parliament, a court's not going to say this act seems like a bad idea, I am not going to enforce it. No, courts will enforce the law because that is their job. But there are sometimes you are called to interpret the law for two reasons. One, where the law itself doesn't have a clear meaning. Two, when the facts may or may not apply to the law. Now, what do I mean by this? Let us say Parliament passes a law tomorrow saying that no person shall be allowed to smoke cigarettes except inside their house. and whosoever smokes a cigarette while not in their house shall be punishable with a fine of 50 lakhs. Let us say that is the law. That is an example I will be using to explain all four to you. Now, it's coming before a court, right? Now, let us say I was smoking a cigarette in my hotel room, right? And that was a hotel room where I was staying for about 3 months long stay. The question before the court would be is whether I breached the act by smoking in a hotel room. Now, obviously, like some smart Alex of you are probably thinking, but if it was a non-smoking room and all of that. No, that's not the point. Understand the question that I'm asking you. The question that I'm saying is, I smoked in a room where I was staying for 3 months, but that wasn't my house. It was a hotel room, clearly, right? And the law says that you can't smoke outside your house. So the question here before the court would be, is a long stay hotel room a house within the meaning of the section? Now, the first thing a court is going to look when it's reading this is what is the intent of Parliament, and that comes under techniques of doctrine. Now, why is this law made? Now, if you look at it, some acts have a preamble. They tell you the rationale behind the law. And every bill presented in Parliament must come with a statement of objection and reasons for the bill. Now, the court is called upon to say whether I breached this smoking act by smoking in my hotel room. So, the word house is not defined in the law. When a word in a statute is not defined, there is a law we call the General Clauses Act, in which certain general terms are defined. Now, our General Clauses Act is not as detailed as many modern interpretation acts that have been passed. Right? But our law is there. So there is the General Clauses. Now, the General Clauses Act is also silent about it. So then what do? We try to look for the plain meaning of the word house. And if the meaning of the word house is dwelling, the question then becomes is, am I dwelling in the hotel room during my period of stay? Like clearly being in a hotel room even overnight is different from being in the hotel's restaurant, right? So the court would come ideally with an interpretation saying that Parliament's intention behind this law was to make sure that people smoke not in public but only in their houses and in a confined space. And since this guy was in a confined space where he was dwelling, which meant that this was his space, the law would not be applicable to him. Now that comes to the third thing, what they bear in mind. They bear in mind the intent of Parliament. Now, let us slightly change the proposition. All right. Let us say I had an independent house with a veranda. Right? And I was smoking a cigarette in my veranda, not in the house. The question now is, did I breach the legislation? Right? Now, remember in the previous funda that we came into while interpreting the previous hotel room example, we concluded that the intent of Parliament was for people not to smoke in public but to smoke inside, correct? One second. Was to, yes, Jackson, I'll come to that. The intent of Parliament was to stop people from smoking in public, right? But I'm at my veranda here. So the question is, if I had to go with the full intent of the statute, you had to ideally restrict my house to the portion that is not visible to the public, right? Because that is the idea of Parliament, which is where we get into special rules for tax and penal statutes, where a law is putting an onerous obligation on you, right? Where the law is putting an onerous obligation on you, the court will bear that in mind and strictly interpret the law. So the rules are very simple. If there is any ambiguity in a tax or a criminal law matter, right, the benefit is given to the defendant or the assessee. Parliament had to say house including veranda. But if there is a doubt, that doubt works in my benefit. Because in a criminal law, there's a criminal penalty. In case of a tax law, there is a monetary levy. Right? So these are onerous obligations. So these have to be strictly interpreted. Okay. So this is what the courts do, and this is what my profession of vakils do. So popularly, people say lawyers are liars. We are not liars. We are just interpreting, showing the court the many possible views that could be taken. Okay. So if you find a court giving you a judgment with a view, unless that view is absurd, your problem is not with the court and your problem is not with the lawyers. Your problem is with Parliament, who recently over the last couple of years has been drafting legislation with typos. All right, you have no idea how irritating it is to see a statute notified in the bloody gazette with a typo. All right, and these typos that are having serious consequences. All right, because there is one typo in a legislation called the IBC, right, which Parliament should not be, technically cannot admit anymore as a typo, but can completely change the meaning of a section. All right, so I don't understand how this works. Like why Parliament doesn't do the thing that other countries do. So other countries, in order to ensure that their Parliament's will is properly implemented, have enacted detailed interpretation acts, and they define everything. And if you read just study a House of Lords committee report or watch a House of Lords debate, okay, something as mindless as a law regarding garden sizes, right? The amount of research that the House of Lords does, and the amount of work that they all do, uh, that's something that I think everyone should appreciate. We never had that quality legislation in India. Even during the British Raj, we never had that quality of legislation. It's just something that's lacking. It's something as a lawyer you feel sad when you do not see Parliament making the same effort you are. Now that being said, let's move to the next one. And Jackson, I think you should ask your question now. Wait, I'll just unmute you for this. No. Yeah. Second. Jackson, can you unmute yourself? I'm not able to figure out how to unmute this.
Can you hear me?
Yeah, I can hear you, Jackson. Yes, so please ask your question.
So my question was, if it's about interpretation, then doesn't that vary from individual to an individual? A same word or a sentence could mean something different to everybody it comes to. So would that then result in a different outcome?
Yes. So, short point on this to sort this out is that is where exactly we come to with the doctrine of precedent. Okay, so there is a rule we like to follow in the common law system, which is that similar facts must have similar outcomes. And this started because, as we explained in the last class, judges used to travel across the country, right? But they all used to meet in London and they used to exchange notes with each other. So they came to an understanding that they wouldn't overrule each other. So the idea is that even if one is the same rank, so let us say there is a city civil court judge in court 2, and he has expressed a view on something, and there is a judge in court 3, and she is about to face a similar situation. Ideally, the judgment of the judge in courtroom number 2 does not bind the lady judge in courtroom number 3, but discipline requires that she that she not differ from the previous opinion expressed unless there are painfully apparent reasons to do so. And if they are, then two judges have had different views, then it goes to the third judge to decide the view. So there is always a decided view of how something has to be interpreted. Yes, there are disputes, but disputes lead to decisions, and decisions become binding based on the hierarchy of courts. So Jackson's question is very important because Jackson's question exactly tells you why precedent matters. Precedent matters just so that different people don't interpret the same thing differently, resulting in chaos and unfairness. Now, your hierarchy of courts basically in India is this. You've got the Supreme Court and the High Courts, and below that the district courts, and below that the other small courts, right? That is one traditional way of looking at it. But I look at it a little differently. You have the Supreme Court and the High Courts, and you have the district courts. And I hold the Supreme Court and the High Court to be co-equal. High Courts to be co-equal. And here's why. Both of them are established by the Constitution. So one, and the Constitution does not say the Supreme Court of India shall be supreme. No. There are cases in which appeals go from the High Court to the Supreme Court. Constitution says law declared by the Supreme Court is binding on all courts in India, right? But the Supreme Court can declare law on the Constitution, so can the High Court. In some cases, the High Court actually has broader powers than the Supreme Court when it comes to superintendence over other courts. Like the High Court has the power to discipline a lower court. The High Court manages all the lower court judiciary in that state. Right? This is the power of superintendence. Supreme Court does not have the power of superintendence over the High Courts because the Supreme Court can't hear revisions. The Supreme Court can hear only appeals. I'll discuss the difference in the next slide where we discuss forms of action. Right? Constitution is silent on who has the power to interpret the Constitution. Earlier, there used to be something that wherever there is a question of the validity of a central law, it shall go before Parliament. Now, this is an Indira Gandhi amendment, no longer, as not before Parliament, shall go before the Supreme Court only. There's an Indira Gandhi amendment, not there anymore. Constitution, all it says is the Supreme Court is there. Supreme Court has the power to deal with substantial questions of law. That's about it. Now, interpretation of the Constitution is something that any court can do. Being a court is different from being a tribunal. All right. A tribunal has no judicial authority. It only has statutory authority. But a court has the power to interpret any law, including the Constitution. It is a little bit of fiction that you think that you can only approach the High Court and the Supreme Court to remedy a breach of a fundamental right by the government. No, you can still file a suit and claim your damages. The question is, what is the relief that you are seeking when you come before a court, when you choose the method of action? But only the High Court and the Supreme Court have the powers of judicial review of administrative action. Right? What is judicial review of administrative action? If the government passes an order on the executive side, you can bring it before a court and say the government has not applied its mind, strike it down. So those powers of judicial review can only be exercised by those two courts, but all courts can declare laws to be valid or invalid from the Constitution. These are known as declarations. So you can file a suit to declare a provision of law invalid. It's called a declaration suit. You can file it, pay the court fee. You can file it before the municipal court also. Now, there's a different question of whether the judgment of the municipal judge will apply beyond the municipality, but it won't because they're limited by their territory as far as their lawmaking ability. That's why you go to the High Court or the Supreme Court. So at least you're pretty sure it's done across the country. So this is the Doctrine of Precedent. You know, I budgeted a lot more time for discussion, but I think we now genuinely have time not just to do an introduction, but to do a proper introduction of this, what I call forms of action. All right. Now, this is a question I'm asking everyone. Feel free to unmute your mics and answer. Can anyone tell me what is the fundamental prerequisite for you to go to court? Anyone? Kaushik, you can answer by unmuting your mic down.
Locus standard.
Is it just locus standi?
Can you hear me?
I can hear you.
Cause of
Is
action.
it locus standi?
Cause of action.
No, I would say that the fundamental precondition for you to go to court is to have a lis. Without a lis, you wouldn't be going to court. Now, a lis is in Latin what we say, what is the word for dispute. You cannot go to, only the president can approach the Supreme Court for an advisory opinion. Okay. You cannot go to a court and say, I want to know what is the position of law, my lords, can you tell me? No. You have to have a dispute. Now, the dispute can either be a question of fact or you can be a question of law. That is known as dispute. The second thing is what Kaushik rightly pointed out, locus standi, right? You must show that you are suffering something because of the dispute, which would require that reliefs be given to you. All right. So that is your locus. The first question the courts ask is, who are you and why are you here and what do you want? Right. So until you're able to, without there being a break in the chain, answer these three questions, you shouldn't approach court. Now, obviously, this doesn't apply for PILs, but you need a locus, you need a list, and you need a relief. Uh, these are the three things you need to go to court, right? So that's called list. Now, what are actions in rem and actions in personam? These are again Latin words. Rem means against the world. Personam means against a particular person or set of persons. All right. So sometimes your right that would be violated is you have rights against the world and you have rights against certain specific people. Let me give you an example about this. Let us say you own a house, right? You have a right to make sure nobody can, to ensure that nobody enters the house without your permission. It doesn't matter if it's X, Y, Z, or it's not that you have to name all the people who are banned from your house, right? You don't have to put a list. It's understood that without your permission, they can't enter. Why? Because you have the right to your property and that right is against the world, right? No matter who tries to come and take your property, you have a right to take them to court, right? A right in personam is different from a right in law. A right in personam is, let us say, your right to receive salary from your employer for the work that you have done. If your employer doesn't pay you, you cannot go sue another employer, right? So the funda is that that is a right in personam because you have that right personally against your employer. You do not have that right in general. All right? Against the world in general. Does anyone have a question? Just unmute yourselves and ask. Hello? Guys, this is important if you guys are planning to stay for more lectures to understand this. Rights in rem and rights in persona. Sure, nobody has a question? Okay. Chalo. Sorry, just 1 second. This my PowerPoint failed again. Yeah. From this slide, Zoom, share screen. Okay, so now let's discuss some basic forms of action, suits, writs, and criminal proceedings, along with reliefs. A suit is your most basic style civil action, and a suit is where you rely largely on unwritten law. So, a suit is when two people have a civil dispute, they can go approach the civil court. A civil dispute is all dispute that is not a criminal matter. Okay, simply just learn it like that. That is the rule of thumb definition you need to learn. So if you don't want to put a person in jail or you don't want them to pay a fine to the government, it's a civil dispute, you go to civil court. Now, civil court is where you go by the suit. Now, what is a suit? A suit is basically a set of facts that are created as a result of a list. So when you have a dispute, you have a cause of action to approach the court. You file a suit. Now, that suit can be against the world or against particular people, depending on what right you are trying to enforce. Now, this suit is just very simple. You put the facts there, the other side will come, the defendant, they will give their version of the facts. Then the little trial judge, whose job will be to say, oh, they agree on these facts, they are disputing these facts. On these facts, you go, please lead evidence. Then you bring your witness, then the other side brings their witness, and the witnesses give their depositions in court, and then the judge is hearing all of this. Then you have final arguments before the judge, and then the judge will be like, there are 10 points where they disputed the facts. On point 1, I find this. On point 2, I find this. On point 3, I find this. On point 4, I find this. Accordingly, this person is entitled to this. This person is entitled to that. The following is ordered. All right. So when you have a dispute civil, you go for suits. You go for writs when you are asking for specific reliefs from the High Court and the Supreme Court. High Courts and Supreme Courts have the power to award writs for violations of fundamental rights. Now, what are the writs that they can have? This will again tell you how poorly worded the Constitution is, by the way. All right. So,
both Article 32 and 226 enumerate writs. All right, writs such as habeas corpus, which is when you're illegally detained, you want your detention reviewed. A writ of quo warranto is when an administrative authority or any authority is acting without authority, without having that authority. It's called a writ of quo warranto. So if tomorrow somebody becomes president without actually having been elected, you file to the Supreme Court for a writ of quo warranto to ask the president to vacate office because he's not allowed to be there. Then the third thing is writs of mandamus, which is a direction to direct a public authority to perform its public function. So let us say the government of India is supposed to maintain this much reserve with the Reserve Bank, and the government has not done it. You go to the court for a mandamus to say, go do your job. All right. Now, these are the last two writs, and they're connected in some level. Writ of prohibition and writ of certiorari. These are the enumerated writs. These are not all the other writs. Even declaratory relief by the Supreme and the High Courts under 226 and 32 is a writ. It's called a writ of declaration. All right. Well, these are the enumerated writs. The last two are prohibition and certiorari. What is a writ of prohibition? When an authority is acting outside their jurisdiction, you can issue a writ of prohibition to stop the proceedings. Okay. So tomorrow, if the income tax authority is screwing around with me in a way that violates my fundamental rights, I can go to the Supreme Court and ask for a writ of prohibition. Then the next writ is the writ of certiorari. Now, certiorari and prohibition are often used together. And the certiorari writ is where you can call from the records of a lower court, correct? And then the higher court reviews the record. Ideally, what it does is the minute the records are called for, the lower court is prohibited from proceeding via a writ of prohibition. If and with the directions of the upper court, it goes back down to the lower court, and then the prohibition is vacated and the certiorari is accordingly vacated. All right. So that's how this happens. Here is the problem with the drafting. All right. The Supreme Court doesn't have the power to issue a writ of certiorari. As in, a certiorari is an order given to a lower court to move the record to the higher court. The Supreme Court has the power to grant leave to appeal from any order in any tribunal under 146. So, as if a magistrate passed a perverse order, I can directly file SLP in the Supreme Court. 9 out of 10, it won't get admitted. I'll be told, you challenge it in the session and the High Court first and then company. But I can do it, right? And then it's an appeal. The Supreme Court sits as a court of appeal. The only other authority from which the Supreme Court can ideally exercise the certiorari power is the High Court, right? And you cannot move. Pradeep, I didn't understand what you said. Yeah, it's certiorari, C-E-R-T-O-R-A-I, certiorari. And I didn't understand your comment, Pradeep, but maybe you can explain it. But that
please ignore.
Pradeep?
Please write. No issues. Please ignore it as of now.
Okay. So what I'm largely trying to say is there is no power for the Supreme Court to exercise certiorari, right? Because you cannot maintain a writ petition to the Supreme Court from the order of the High Court. Okay, that is one. Second, you cannot, if there is a problem with a lower authority, the only person you can bring that writ to is under 227 before the High Court, because the High Court has the superintending power, right? You can file an SLP in the Supreme Court, right? But you cannot make a 32 challenge out of an order of a magistrate. Now, this distinction, so this tells you how poorly worded our constitution is, right? They basically took 5 writs and they put the same thing in 227 as well as 32, and you cannot really use that writ in 32. But whereas writs that can be used under Article 32 are not enumerated, such as the writ of declaration, which is what you really effectively claim in the Supreme Court most of the time. You ask for a declaratory relief followed by an order that flows from the declaration. You want this law to be declared unconstitutional, right? That is what you go to the Supreme Court for, to declare that XYZ has violated your fundamental rights. or you go to the High Court 400, 226. So when you look at your constitution, right, especially there is this habit amongst a lot of senior lawyers to just give nothing but praise for this constitution, right? Ask them about the typo. Ask them why the Supreme Court has been given a power of certiorari that I still, and I'm caveating it in here, I still haven't figured out a way for this power to be used by the Supreme Court. Ask them, what were our drafters doing? Why is this there? As in my view, like this just shows non-application of mind at the time of drafting. But people will take differing views, as in our constituent assembly has now been deified into saints. We can't critique them without being accused of sedition. We can't critique government without being accused of sedition. But you seriously, we need to critique this constitution. We need to stop thinking that this is the most perfect thing that has come down. No, it's not. Like this typo, like certiorari in 32 is a typo. Now let's come to criminal proceedings. Now, in a criminal proceeding, you are asking for two kinds of relief. That XYZ should either be locked up or put to death, and also required to pay a fine. Those are the only two reliefs. Now, criminal proceedings have to be brought before criminal courts. Surprisingly enough, the way the action moves is the same. The only thing different is what you're required to do as a defendant. Okay, so the state brings a complaint or an FIR. Private parties can also go do this, but certain crimes only the government is allowed to prosecute it. So without permission, I cannot, of the state government or the court, I cannot bring a prosecution for, let us say, murder. So the state government has decided that there is not enough evidence to prosecute XYZ. I can keep challenging the government of the state government, but I cannot go to the criminal court and say, government doesn't want to prosecute you, let me prosecute that person for X, for committing murder. So this is the Crown's privilege as far as it comes to bringing a prosecution. In a criminal proceeding, it starts with this complaint and an FIR. The difference is, the FIR gets converted to a charge sheet which functions as a complaint. So I'm just going to put them together and say complaint, because I'm not going to go into things like arrest, detention, investigation right now, because that's an entire series on the CRPC that we have to understand. But here in a criminal proceeding, you say X has broken this law. Then the judge reads the charge sheet or reads the complaint, and then the judge frames the charge, saying that we hereby charge that you, A.B., did on so and so date do the following in contravention of the following act. Therefore, you are liable to be punished. This is the charge, right? The question we have to ask now is from the court is, hello? Yeah, from the court, the question that the court puts to the accused on the dock is, do you plead guilty or not guilty? Now, the minute the accused pleads guilty, you move into sentencing. Because that means you admit the fact. The minute you plead not guilty, that means you dispute the Crown's position. Now, there are two ways of doing a criminal defense, unlike a civil defense. Three actually. So, one is you can say nothing. Because unlike a civil court, in a criminal court, the burden is only on the prosecution to prove your guilt. You are not required to prove innocence in a criminal court. So the prosecution must establish beyond all reasonable doubt that you have committed the crime, which means you have the right to stay absolutely silent. Then there are two things you can do for a defense. One, you are allowed to present your own alternative case. Now remember, once you decide to present an alternative view of the fact, burden shifts on you to prove your alternative view, because burden is on that person who asserts, not on that person who denies, right? So you are asserting that this happened, not what the government said happened. You have to prove that. Or what you can do is you can accept the facts as stated by the government and plead an affirmative defense to say that even if all the facts are taken together, I have not committed a crime. The only difference is if without having to show an affirmative reason, and by an affirmative reason, I mean to say self-defense or something like that. Hi, Renuka, can you hear me now?
Renuka, just confirm on chat if you can hear me now. I'm being louder. So what I'm saying is, yeah. So what I mean by an affirmative defense, let us say someone is coming at me with a knife and I had a gun on me, I shot them. Now you could say I've committed the crime of culpable homicide. I will come and say I exercise the right of private defense. I am not disputing that I shot the man. I'm just saying I had the right to shoot the man. That is an aft defense, right? Now, if whatever the Crown says, whatever the court, as in the charge sheet says, on its own does not meet the elements of murder or a crime, I can ask for that to be dismissed then and there. Now, in foreign courts, this proceeding is called no case to answer. In Indian courts, this is called discharge, right? So you can discharge yourself from some of the charges or all the charges, and then you can plead your affirmative defenses where you want to. So criminal lawyers decide on the strategy, because as you would have understood from how I've explained it, it would have become apparent that it's very difficult for you to go with the 100% denials at the same time presenting an alternative case and at the same time presenting a affirmative defense. So it becomes a very dodgy thing to try and do all three. It's very difficult to do all three. So the law gives you a little bit of a liberty, saying that you can't be tried for more than 3 crimes in the same trial. Okay, so the funda being that, yeah, you are allowed some leeway as to how you want to do this, but please pick a stance that if you want to go with 100% denials and exercise your right to silence, do it. If you want to present an alternative case theory, do it. But at that point, you have to prove your alternative case theory. Doesn't mean we'll accept the prosecution's version as God. But if the prosecution manages to prove beyond reasonable doubt that its theory happened, you're still screwed. So you sometimes tend to people will present alternative case theories with a view of disputing the Crown's evidence, King's evidence. So to create a proof thing that look, this could have also happened, this could have also happened. So these are known as the alternative case theories. But in a pure denials-based defense, you would have to say that what the Crown is saying cannot have happened. It's a leap of logic. It could have also possibly been this. So these are the differences. Now your reliefs are generally of two kinds: declaratory and injunctive. I would classify all reliefs in criminal law as injunctive also, because at the end of the day, what the Crown is basically asking in a relief is for an order directing that this person be locked up or hanged or a fine be levied on this person. So it's an order of direction. So anything that tells you to do or not do a thing is injunctive. A declaration is when you say it out loud. Okay. So now the last thing I want to talk to you about is declaration. So when I remember in the first slide, I talked to you about unwritten law, which is declared and undeclared. If after going through all of this, the court finds that there is a portion of the law that needs to be stated, the court will state that. And that is called the declaration of the law. So, and that becomes important because only the declared law is the binding law before all courts. So even the Constitution in 141 says law declared by the Supreme Court shall be binding on all other courts. So that is known as declaration. Merely because, so if tomorrow the Supreme Court declares a statute unconstitutional, what it has done is it has declared it as unconstitutional from the beginning. So if this is an act enacted in 1950, declared unconstitutional today in 2020, it would have been invalid for 70 years, and everything done under that act for the last 70 years would have automatically been invalid, because from poison only poison may flow. But Supreme Court, in its wisdom, in order to do complete justice, has developed this concept known as prospective overruling, where in 2020, if they declare something unconstitutional, it will only apply from now onwards, not previously, which is really painful when it comes to criminal statutes, but there are people who could have been in jail serving sentences for crimes which have been declared unconstitutional, but still won't be covered by the fact that they're declared unconstitutional. So if something has been prospectively overruled and you have been sentenced against under it when it wasn't declared unconstitutional, but you're still stuck to live that sentence if they use prospective overruling. If they say it's been void from the beginning, then you can apply to the court for a relief saying you're being illegally detained. You can immediately move a habeas. So, for example, 377, the minute 377 was declared invalid, every person in this country who was serving a prison term for just 377 or had been detained on the suspicion of committing 377 for consensual same-sex intercourse could have moved a habeas, because that would have at that point been unlawful detention. So that is the importance of courts declaring the law. So now I'm opening the floor for questions. Unmute your mics, ask your questions. If you don't have questions, if you want to run a question by me before you ask it, post it in the chat. But we've now come to the end of this seminar. So does anyone have questions? Anyone? Oh, yes. Yeah, Ishani.
Hello.
Yeah, Ishani, tell me.
Hi. Can you please explain the last bit where you said if any person detained under section Article 377, if they were detained even after it was held invalid, they could have moved the habeas.
No, that's not what I said.
I don't know how.
No, that's not what I said.
What did you say?
What I said was this. So let us say 377 was declared unconstitutional last year, right? Sorry, the year before that, right? So if on the date of it being declared unconstitutional, there were people serving prison terms for offenses under 377, or people who had been detained in connection with an offense under 377, for the consensual activity, right, which was criminalized.
Right.
Their detention would have been automatically illegal because 377 would have been invalid from 26 January 1950 onwards, the date of the commencement of Part 3. Okay. So that is void ab initio. All right. So it is void from the beginning itself. All right. There is also a doctrine where the Supreme Court could have said, using its powers under 142, I think, of the Constitution to do complete justice, it would have said that nothing in this judgment will apply to actions undertaken prior to this judgment. Okay. So at that point, it would have resulted in a very strange proposition where two people for the exact same thing, right? One person would continue to serve a jail term while the other person would be able to do it in exercise of a fundamental right. So a declaration is important because when you declare you declare the law as always having existed. Okay.
Okay.
So when the Supreme Court says 377 is unconstitutional, what the Supreme Court is basically saying is 377 has always been unconstitutional. Okay.
Okay. Yeah.
But that may result in chaos for, let us not just say criminal statutes, let us say something like reservation. Okay. So what do you do if it takes 5 years for a case to move from the High Court to the Supreme Court? And in those 5 years, you have already admitted students and given them degrees, right? So if the Supreme Court then strikes down the reservation, if it doesn't bring in the doctrine of prospective overruling, where it says that only things from henceforth will be a problem, what you have is you have those students in the 5 years, their degrees are suddenly in question, right? So because their admission would have been unconstitutional, right? So that creates a problem. So this is what we mean by declaration. So remember, when you're applying for a declaration, from the date you're claiming the law is invalid is that date. And for Part 3 violations is always 26 January 1950. Right? Then the Supreme Court has the power to temper it.
Okay. Got it.
All right. Chalo, any other questions, guys? Just unmute and ask. All right. Yeah, Aarti, if you guys have question, okay, Abhishek Banerjee. Abhishek, why don't you just unmute and ask the question if that's okay, yeah, so everyone can hear it.
Hello, hi.
Yeah, Abhishek, come on, ask.
Yeah, so if there is any difference in interpretation of any law or word, suppose there's an ordinance also in place which has not repealed any prior statute, and there are rules also, and there is a difference, and it comes to the court how to interpret the same thing. So which one, like, what would prevail? Will the
Ah,
ordinance have a more it will be more prominent because it has been latest in time, or what is the law about it?
so what you have asked is a very important question, and what this is what we call the doctrine of implicit repeal. Okay, let us say there is a law that says you have to do X, right? But then the law changes to say that you have to do Y. Uh, but the previous law that said you had to do X is not repealed. So what the court will most likely do is say Parliament by its will has implicitly made the previous law invalid. Therefore, the previous law is no longer effective. So Parliament will declare that previous law, as in the court will declare that previous law invalid, even though it has not been formally repealed. All right. So, so there are multiple ways, except when you're talking about special statutes. So what you've asked is a question that regards rules of statutory interpretation. So let us say if there is a general law and a special law, and the general law has been replaced by another general law, there are some doctrines which say that the special law is not implicitly overruled. Okay, because it was made for a special purpose. So if you want a good source on it, I can give you a good textbook. I can put you through a good textbook on statutory interpretation, or you can just wait till I discuss all the rules in the coming few seminars, depending on how long we have COVID. So right now, so
Thanks.
yeah,
Anything would be great.
yeah. So just let me know, right? Because I'm planning to take another one on this, because this is what you asked is a very interesting question. So doctrine of implicit repeal,
But
explicit repeal.
something like I didn't. There's a difference actually. Suppose I forget about the ordinance part. Okay. Now there's a law, there's a rule, and there's a regulation.
The statute
Like
prevails over the rule.
okay, so like where do I get that? Like it's a basic understanding also that I have that statute prevails over the regulations. But like where do I exactly? Is it unwritten
Uh,
kind of certain doctrine or
a delegate cannot exceed the authority of his delegation, right? So if the
right?
rule has been made by the central government in pursuant to a power given to the central government by parliament, right? The central government cannot exceed the scope of the power that parliament has vested. So if XYZ may make rules, right? The rules cannot be inconsistent with the act. So if the act defines the word Burma, right, and as being Myanmar, and if the act uses the word Burma and the rules use the word Myanmar, even though they're one or the same thing, you will have to go with Burma, right? But then there is also harmonious construction, as Kaushik has pointed out now. Kaushik, would you like to talk about harmonious construction for a minute? Kaushik is a colleague of mine. He's an advocate in Madras, so he might have
Okay.
to use to. Kaushik? All right, I think Kaushik is a bit tired. He's saying I have a chat. But anyway, yeah, so harmonious construction is ideally what a court would do is it would try to interpret the rule and the statute in a harmonious manner, right? They generally don't like saying XYZ is outside the scope. They try to achieve the object, right? But it's a general rule of jurisprudence that a delegate cannot exceed the authority that has been delegated to that person. So it's just like if your mother tells you you have to go buy milk, your mother has implicitly given you the authority to decide what brand of milk to buy, but you cannot come back with orange juice and say you've complied with the statute. Okay?
I get it. Thank you so much.
No problem. All right, guys, any other questions or can I end the call? All right, thank you all for signing in. I hope you enjoyed it. And if you have doubts, I'm available on email. You would have got it with your registration links. And what I'm largely saying is I appreciate feedback. So if you think that I could have improved in any way or improved the class in any way, feel free to let me know. I had a lot of fun doing this. I hope you all had a lot of fun too. And next week, I will be posting on my Insta and Facebook the schedule. We are going to do the Constitution, which is something I think all of you might be looking forward to. Chalo, bye people.